Are you in the middle of a felony case and you're not sure what a motion to quash is? My name is Carl Birkhead. I'm an attorney with Wirth Law Office. I've been practicing criminal law for about 7 years, and I want to help you make law easy by telling you a little bit more about this specific stage in the felony process. So if you're going through a felony case and your attorney starts throwing around the terms motion to quash, we're going to talk about what that means. It means that you've already been at preliminary hearing. I've talked at length about what a prelim is, and I'm just going to give you the quick blurb. Prelim is going to be where the state has to put on their basic case, where they're showing that it's more likely than not that a crime was committed. The court's already ruled in the state's favor and bound you over to the district court level, so now you're in front of a new judge. At that point, if your attorney is telling you that they don't believe that the state should have won at prelim, you're going to be hearing your attorney talking about filing this motion to quash. So you'll get to your arraignment. Your attorney is going to stand mute and announce to the judge that they need time to get the transcript from that hearing so that they can file the appropriate motions. This motion to quash is basically your attorney filing a paperwork with the court stating, hey, we had this hearing at whatever date that we had it. And although that judge found that there was enough evidence to keep the case alive and bring it before this court, before this judge, with all due respect, that judge was wrong. They never should have let it get to this point. And we are asking you, the honorable, wise, learned judge that we are in front of now, to just correct this error and dismiss the case. So if usually what I'm looking at here is I'm looking at what are the elements of the crime. You can look at the Oklahoma Uniform Jury Instructions to figure out what the elements are. And it's broken down into two main components. There's the mens rea and the actus reus. These words sound weird because they are, because as lawyers we like to use our Latin. The mens rea is the mental aspect of it. It's did you intend to commit this crime? Or if it's not an intentional crime, were you negligent, and because of your negligence the crime was committed? The actus reus is the act itself. It's basically the physical act of committing the crime. As an example, if I'm charged with assault and battery, the mens rea is the intent to punch someone. The actus reus is the actual punching. So I'll look at those elements and I'll go to our new court and say, hey court, my client's charged with assault and battery. But here's the deal. They weren't trying to punch the defendant. They're a boxer. They're at the gym. They were punching the punching bag. And oh no, someone called their name. They turned. They accidentally punched the other guy. They never intended to do it. There was no intent. The mens rea is not there. That's what I mean. We'll look at the elements of the crime and we're going to try to show the court that at the lower level, the state did not meet their burden of proof. They didn't show that the elements were there, and therefore the case has to be dismissed. It really depends on the case whether or not you're going to prevail on this motion, but it's something that you really want to talk with your lawyer about whether or not it's worth it to file. Because even if the court doesn't grant the motion and the case moves on to trial, it's at least there and it's part of the record. So that way, if the worst should happen and you get convicted, that's an issue that you can then raise on appeal. If you have questions about this, if you're not sure where you're at in the felony process, or if you just need some help, give us a call. My name is Carl Birkhead. I'm with Wirth Law Office, and I want to help you make law easy. Thank you.